This is not your everyday podcast. Real conversations, real stories. Well, thank you everyone for tuning in to Innovators and Litigators. Today we have a special treat for you. He's a man I deeply respect, not only for his legal prowess, but also being an incredible human being and father. He's the founder of BladeInjuryLaw, located at Atlanta, Georgia, and the illustrious attorney Linton Blade Thompson. Thank you for joining us today.
Thank you, Nick.
So if you start off, we've known each other for a while, and I do a little research on my guests before they come in. You have an exceedingly dope name. And so you got Linton from your father, is that correct?
Yes.
Are you a junior? Are you not?
I'm not, no,
Okay.
but it's the southern pronunciation is Lennon.
Lennon.
And so my family has told me. And so I always get called Linton, and so does my dad. But yeah, Lennon is a family name on the Thompson side. But Blade is not. Blade is
Lennon.
unique.
I
I'm
like
the
it.
first. I'm the first Blade.
My dad he called himself the third. His name was Lester, but he had an interesting middle name as well. He was a Venus, but his dad wasn't a Venus. And I'm like, you're not a third then.
Yeah, I don't know what it is, but my family tradition is my father goes by his middle name, which is Lennon or Linton, and I go by my middle name, which is Blade. And my dad named me Blade because he thinks I'm so sharp.
Really?
Yes.
I love it. I always wanted to ask you that. That's really cool. So that's it. There's nothing else to it.
That's right.
That's very cool. So the whole point of this podcast and the reason we do it is kind of to dispel kind of the stories that are out there on social media. I don't know how much time you spend on social media and people promising how to become a millionaire quickly, how to build a business tomorrow, take a single course.
It's everywhere.
Yeah, and I think you're uniquely kind of in the pulse of things like this. So kind of tell me your story when it came to, I know you worked at least in conjunction somewhat with Alexander Schnyder for a little while. Kind of tell us your story from where you kind of started law firm ownership or really personal injury practice up till now.
When I was in law school, I clerked for a personal injury firm in Macon, Georgia, called Reynolds, Horn, and Servant. And I just remember walking down the hallways and seeing the news clipping articles of all the outcomes and the changes they made to make our world safer, whether it was defective tires, whether it was tractor trailers and trucking companies not keeping, their drivers safe on the road, or it was just your basic, slip and fall at a grocery store. And why is that a problem? And so it got me thinking, like, these people are actually doing something more than just making money. They're changing outcomes. They're making the world safer. I want to do that. I want to be a person that helps people every day and can be proud of the work I do, and so it all started then with my journey. Candidly, I think I was more interested in being more of a Matlock or Perry Mason type attorney, and who would represent people in all different cases, criminal, civil, family, whatever. But for me, it was really just realizing through the guidance of other mentors and through my own experience that helping change outcomes for people who are victims of tractor-trailer crashes, motor vehicle collisions, slip and falls, explosions, products defects, those kind of things were very interesting. And so I always wanted to be a doctor, and I didn't really like the path to being a doctor. So being a lawyer and being able to help people in the healthcare industry is amazing, and it helps me fulfill that dream from years ago when I thought I was going to be wearing a white coat.
How long did you work for someone else versus owning your own firm? Because I'm always interested by that. People always want to know.
In 2011, I started out practicing law by doing court-appointed work, serving as a guardian ad litem, and doing criminal defense appointed work to kind of get my feet wet while I was taking all these bar exams, which we'll get into in a moment. And then I worked for a state court judge for a couple months during the time that I was taking all these bar exams from 2011 to 2012. So I had those jobs going. And through those jobs, I got to see a lot of trials, got to help, people who are on jury duty actually escort them through that whole process to get them to the actual courtroom, and then help the jury while they're actually deliberating or throughout the trial process. So I got to see things that most lawyers don't get to see when I worked for a judge. Eventually, I landed a job with a plaintiff's firm in Daphne, Alabama. I moved to Alabama briefly, not from there, just moved down there for a period of time, 3.5 years. And I got exposed to personal injury, particularly in the products liability side, because now I don't really do anything with property damage, right? And so I do handle property damage for my clients when car wrecks, but I mean, you know, a lot of my practice is focusing more on bodily injury claims, not, you know, there's this defective stucco on this condo unit in Fairhope, Alabama, right? So I was doing a lot of that work, and eventually had an opportunity to go out on my own and work some like a mass tort case dealing with ethyl mercaptan, which is, you know, mercaptan's mixed with gas to make it smell, so you know it's in the room, you know, to get out or not light a match, right? So I was handling that case while also working some personal injury and workers' compensation cases for other lawyers on a contract basis. And I kind of started BladeInjuryLaw, really Blade Thompson LLC, back in like, you know, 2012, 2013. And then through that process, I eventually got offered a job to come up to Atlanta and open up an office for the Schnyder firm, a very, you know, large law firm. And that was a wonderful experience. It taught me a lot of what not to do and what to do. So I've looked back on that experience as positive. But after working for Schnyder for about 3.5 years or so, in 2019, my wife and I founded BladeInjuryLaw, and we haven't looked back.
What do you feel like the biggest difference between owning a law firm and just, you know, I want to say just, it's not to demean it, but just being a lawyer, a trial advocate and things like that? Like, what do you feel like the biggest difference is for you?
I think it's realizing that you have to live it every day, and knowing that you're on call. You're going to get that call when you're at family dinners, and you have to just put that phone away. And that's something that we've recently started at our dinner time with with my wife and kids. Is we put the cell phones away, and we're trying to do it for at least 2 hours in the evening, and of course, you know, that hour in the morning when we're getting the kids ready for school. But I think it's just knowing every day that there's something that I need to do for the business or for the actual practice of law, and being able to balance the boundaries, because I don't want to do this on weekends. You know, I don't want to do this late at night, but then I sometimes find myself with my laptop in my bed before I go to sleep. So it's rewarding, and I don't want to practice law the rest of my life. I'd like to retire in my early 50s, so it's worth it.
One thing I am impressed with, and I notice that you focus on a lot, is work-life balance, which is interesting because you work with your wife in the practice. So first, I'll kind of start with the first question is, walk me through how it's like working with your wife, and she's in the room, so this should be fun.
Yeah. So when we were engaged, a lot of people gave me a lot of advice, and the most common advice was happy wife, happy life. And my wife is brilliant. She's got a business mind like no other, and I don't. So our strengths and weaknesses complement each other in such a way that we're able to not only focus on our family and ourselves, but focus on our business and set, and this is a practice, it's hard, to set boundaries to turn off the business and try to focus on our personal stuff. And so it's actually really rewarding. I know a lot of attorneys or business people tell me, like, I could never work with my spouse or my partner or whoever that might be. And I'd say, you know, I thought the same thing. We thought the same thing. And then we tried it, and it's actually made our relationship 100 times better.
That's amazing. I love my wife. We have very different strengths. I can't imagine. And she knows that. She sees the stress that I come home with. And we talk a lot about work-life balance, because it's hard for me to put the phone down. But when I think about it, you know, I used to work for someone else, and it was 7 to 7. I would leave early. I would come home late. And so when she would initially get frustrated with, well, you're on your phone all the time, and all the different things, but I'm like, but we're on a beach, or we're in Italy. Like, yeah, there's a reason I'm on my phone, but I'm not glued to a desk. And so for me, it feels like that's kind of the price you pay, is you kind of get glued to it. But I feel like you have a different approach. Like, you really work hard to draw a line in the sand.
Yeah. So, I mean, sometimes you just got to go hide yourself in the bathroom for a few minutes and check your messages, you know, or hide in the closet, whatever you got to do to kind of like step away so that your family knows, okay, daddy's gone to briefly take a moment to whatever, go change clothes or put on some shoes or maybe go to the bathroom, but we don't know. But daddy's not in the room. And that way I'm not like, you know, I'm showing my children and my wife like, okay, I'll step away and use my phone. Is that reality? No. I will habitually pull out my phone in front of them. And I don't want my kids, you know, picturing me just on my phone all the time.
Right.
And that's hard. And I've learned, like, I've got to put this doggone phone away.
Yeah.
Yeah.
And that's another thing I want to discuss. I think you can uniquely explain to our audience is there's this concept that there's one way to success. There's one way that you can be successful. One way you can become a multimillionaire is you wake up every day, you meditate, you eat the right thing, and you grind, 24/7. And as long as you outwork your opponents, or you do this for so long, there's a specific equation to it. But our practices are so different, and yet I see you as incredibly successful. And so that's what if you can, just kind of explained how you've done things differently than your peers, with having such a small relative crew, and still getting really good results and still growing at a fast pace and working with your family members. Kind of explain the path that you've taken that's different than, grind all day and never put your phone away.
I never wanted to be the attorney that grinds all day or makes the best grades or has the best job at King and Spalding. That path, thanks to John Grisham, there's a book called The Associate. I read it and I'm like, heck no, I'm not doing this. So I kind of like torpedoed my law school grades to make sure I was just kind of average and not like excellent, because I didn't want to get trapped at some like big King and Spalding firm. Seriously.
Wow.
So that was easy for me to be like, oh, I'm going to slack a little bit in law school, right? Well, that was kind of my goals, because I did not want that path in my life. And so I wanted a job that no matter what money I made, that I could work like a structured set of hours and focus more on what's more important, my family and life, right? Because we never know when we're going to go. And I want to make sure that in the moments I have with my children at this age, that I'm there. And that's why I pretty much work from home, and I get to take my kids to school, get to see them when they come home, get to go play with them on the swing set, take breaks from work, still get work done, but make those moments, where I'm taking time away from work to say to my kids, I value you, or say to my wife, I value you. And am I always like that? No, I miss the mark a lot. So I think the things where I'm different is, I remember what Jerry Spence said, famous trial lawyer: be who you are. Be who you are. And I am this really laid back, nice guy that if you push my buttons, I'm going to come at you, and I'm going to come at you with compassion and zealous advocacy. So when insurance companies or their defense attorneys light that match, it explodes in their face. And I think they know that now, and know that if you try to attack my clients in a way that's beyond, professional or ethical means, that there's going to be consequences. And I think that's why I don't know if it was sports growing up or just me being a short little guy, that I have this fighting spirit, and I don't know if that's the Irish ancestry in me, but as far as keeping what's my model and how do I keep it simple? I mean, I built it around what did I want in life. I wanted to be able to work from home. I wanted to be able to be successful, to replicate and build upon every case. And so that's why I think the power of a system is so important. And that's what we use at my firm. We use systems, we use technology, we use automation, we use AI to a very limited extent. And we try to make our clients feel like they're the most important person in the room. And that's why it's a blessing and a curse to sometimes give out your cell phone number to clients. But we use an app called Case Status that I think is really brilliant, because all of our clients are on there, all my paralegals are on there, and that system has allowed us to better manage our clients without taking us away from productivity. Not to mention Filevine, which I know there's a lot of haters of Filevine out there in the legal world, which is fine. You have your reasons, but I've been using Filevine since 2017, and I keep it simple, and it works. And I try to delegate things out to staff. I know a lot of lawyers have said this, but Mike Rafey said this on a social media reel, and I thought it was brilliant. It was just that, hey, if this is a task that I can delegate to a non-lawyer, it needs to be delegated out.
Correct.
And that really stuck with me. I've heard that many times from other lawyers, but it stuck with me. And so I've been trying to do that more and more.
When I was growing my firm, it was literally just me, licking every envelope, taking out the trash.
Yeah.
I had no employees, which was a mistake. But, I look back and think about how much time and money and effort I wasted. doing the most simple tasks that could have been handled by somebody else for much cheaper. So, but I think you're incredible at that and focusing on technology, and you've spoken on that several times. But to return back to kind of the biting thing about you, so I really do think you come off as unassuming. You're very kind. That's something I like about you. But occasionally I'll kind of see you show that fire, and I love that about you. And one of the things that you don't just focus on the practice, but you've spoken several times in social media and things like that about the broader implications of people's actions and things like that. So not only the insurance companies, but our peers.
Right.
And so you've spoken on certain actions that other attorneys have taken that can spur tort reform or can harm clients in the long run. Can you kind of talk about things you've observed?
Yeah. So I think that a lot of attorneys get caught up in what are other lawyers doing as opposed to what is the message I'm sending and how am I communicating this and what is the impact? What is the implication? So I have no problem with money guns or big checks as long as they're used in the right context. And so my concern is, I remember one of my first seven-figure settlements, a case that settled for over $1 million. I ran a brief ad on social media that was a picture of the damage to the car, and this was years ago that I did this, and I can't remember what we actually said on the picture. It might have been, this case, settled for seven figures or something like that. And there was this troll on Facebook, and this guy had to have been like in his, later years in life, and he was just commenting, ambulance chaser. And that really bothered me because I'm not an ambulance chaser. I'm an ethical lawyer. And I realized, like, oh my gosh, right? Or I like to sometimes say, call Blade, get paid, right? Well, there's call Cade, get paid. There's all these various play on words that you can have with your name. And I remember a client one time telling me that she didn't like that. It made her feel uncomfortable, made her feel dirty, almost unclean. Made her feel not, like bringing this claim made it just tainted the water. Right. So that's why I'm not a fan of pictures of property damage to say, guess what this case settled for? Guess what the injury claim settled for by looking at the property damage? Because that's not the truth. You can't look at a picture of someone's car and tell how injured they are. The science is just not there. Likewise, I've got a social media reel of me and Melissa at a party with a 360 cam, and I'm holding a money gun, shooting out money, and I'm like, well, this is fun. We're at a party, right? There's a time and a place for it. We're trying to portray ourselves as ethical attorneys who have to set a higher bar than most lawyers because we are already criticized enough by the insurance companies and lobbyists for tort reform that we always have to carry a higher level of ethics and professionalism in our practice. Same thing with our cases when we're approaching them in court. We have to be, the truth has to be on our side. We have to be portraying the truth, not exaggerating the truth, not undermining what really happened. So I think it all ties down to is your messaging, like if you're going to use a money gun, use it to be funny.
Right.
Don't use a big fake check to try to say, I'm professional, I'm ethical, all this stuff. Don't use those kind of things when you're trying to be serious is all I'm trying to say. Use it for what they're meant for, and that's fun, it's goofy, and it's entertainment. But we're not entertainers.
Right.
We're lawyers.
Right.
Our job is to make sure our messaging doesn't lead a lobbyist to taking a picture of a fake check, showing it to a senator that doesn't know anything about personal injury law, and having that senator sponsor a bill that's going to make it harder for injured people to recover money in, an auto crash, for example. And so that's the big harm that I'm like a critic of, is think about how this is going to be used at the Gold Dome here in Georgia to send the wrong message to our elected officials that make them feel like that they need to act and they need to stop, these cases where people are getting something from nothing. Well, the truth is there's no such thing as a case like that. We already have those legal mechanisms in place, but that's the lie that big corporations and big insurance companies are telling our state legislatures, or the state legislature themselves is receiving a check for several $1,000s, maybe even over $100,000 from these lobbyists to just say, all right, take the money. I know you disagree with me, but we want you to sponsor our bill. And that's the problem. That's the problem.
I love the term ambulance chaser, and I'm so glad you brought it up. Because when I was in law school, I used to act and things like that, and so I always assumed I'd be an entertainment lawyer or a contract lawyer. I never knew what I was going to do. I was first generation everything, so no one taught me anything. And so then when I initially got the job to work in personal injury, I was kind of like, I didn't really have an interest in it, and it really was muddied by this powerful concept that I believe insurance companies have spent billions perpetuating, is this concept of ambulance chasing. And it really bothered me. And I used to like the big check concept. I was like, look at that, look what we're doing. Right. It's so flashy. It makes people want to understand that we add value to being involved. But now, personally, I can't stand it. And I want to dig a little deeper into it because I always find it so hypocritical for a company who has their name on sports arenas and owns blocks of our city to call us ambulance chasers, to call us the ones chasing all this money and making it.
And the truth is that those companies like State Farm, Allstate, all of them do it. They will cold call somebody after they get notice that the claim was filed. They'll cold call the injured party who's unrepresented and try to get them to take a fraction of what it's worth and not explain to them what their options are. They just try to bulldoze over the public. And I think those attorneys that do the money guns, the fake checks, or the pictures trying to guess what the value of the injury claim is, I think they have good intentions. I don't think they're really trying to they're not bad lawyers per se. I think they're misunderstanding their messaging. Lawyers are not business people. We're not marketing specialists. We have to hire people like that, just like doctors have to hire business people to manage their medical practice or hospital. Once you kind of understand how your messaging is being received, I'm sure if those lawyers actually sent a focus group those images before they posted them on social media, they probably would get enough feedback where they might change their messaging, right? But that's usually not what we do. We kind of throw it out there and see if it sticks, and sometimes it backfires.
A lot of firms take what John Morgan calls the last best offer prior to filing suit or things like that. But you and I kind of focus more into litigation and things like that. So I wanted you to kind of walk our audience through the way you approach resolving a case prior to filing a lawsuit. That's what we mean by litigation versus deciding to file a lawsuit and moving further.
You got to know your audience, right? My audience in the pre-litigation phase is an insurance company, their claims department, an adjuster handling that case or claim, and a software that they use to evaluate the claim to help give them a range of authority to resolve it. So I use a software called Settlement Intelligence that was founded or created by Charlotte Sinclair and Aaron DeShaw. Aaron DeShaw founded Trial Guides, a publishing company for plaintiffs, lawyers who do what I do and Nick does, and criminal defense attorneys. So anyway, I've been consulting with them for years, and they recently developed the actual software so that law firms could subscribe to their software and have their staff or the attorney enter the data to help generate and format the demand letter so everything's nice and organized. So even though it takes us time to put together the demand and make sure we've got all the points, so to speak, when we generate it and send it out, within just a matter of days, we're getting either an acceptance letter or we're getting a counteroffer that is a lot higher than what I ever expected. And then I can go to the client and say, hey, instead of my normal old self would be like, we need to file suit right now. That's an insulting offer. We don't even need to negotiate. Instead, I say, client, this is the offer. If we get them to this number, you will walk away with this much money. Oh, you're okay with that? All right, well, then I will go and I will see if I can get them to that. But if they don't get them to that, we're going to file a lawsuit, okay? Okay. Then explain to the client, hey, the fee goes up, expenses are going to go up, we're good, so we know the path we're going to go. And most of the time, at least 50%, greater than 50% of the time, it resolves. Not because I'm trying to settle a case pre-lit for less than the value I could in lit. It's because I'm actually getting those values now. And there's a couple reasons for that. One, insurance companies track lawyers by their tax ID number. They know which lawyers sit on the sidelines and which ones will actually go to court and litigate the case to verdict. The other thing is that if you take the time to organize and present your case from the start, it just makes everything else kind of roll smoothly from there. So I do have clients that get frustrated because they've been, it's been like 60 days or more since they last saw a doctor, and they're like, well, why hasn't the offer gone out? And it's because we are building the right case and gathering additional documents, maybe even getting an impairment rating done to help further get the points we need to get the claim settled in the insurance company software. Now, when we shift into litigation, I'm dealing with a defense attorney who's looking at this from a whole different perspective. So I'm not just going to send the defense lawyer the offer meant for the claim software. I'm going to send them that information too, but I'm also going to know who my audience is, right? It's a defense attorney. Let's talk about what really matters here and the good and the bad. So I think for me, I've noticed that I've had cases where I get like, kid you not, Nick, I know you've had this too. You'll get like a $10,000 offer before you file the lawsuit, and then you wind up settling that case for a lot more. I had a case that I settled for $1 million during the pandemic. That the first offer was $10,000. I sent them all the records, but that was just where they were, and it was silly, but that's what they did. And so I say all that because obviously litigation matters. There's a lot of attorneys that might listen to this, and they think, oh, I have to do all this myself. I can't ask Nick or Blade or whoever for help. That's the wrong approach. My model is just one lawyer, one law firm. I'm the asset at my firm. That's why people come to me, is because they're going to work with me. But I'm not stupid. I'm going to reach out to Nick when I have a case and I'm like, there's a lot of work that needs to be done. That doesn't mean the client is paying double attorney's fees. No, it just means me and Nick are splitting whatever the attorney's fee is in our contract so that the clients are able to get a team of lawyers, right, to help resolve their case. If I have a tractor trailer case and it goes into federal court, that's a lot of paper, a lot of motions, a lot of other stuff, a lot of depositions. I might get 2, maybe 3 lawyers involved depending on the potential value of the case, and we work it together. No lawyer should try a case by themselves unless they are Jerry Spence or Nick Rowley. Nick Rowley doesn't try cases by himself. So, and the truth is, less than 1% of these cases actually go to a jury trial, which I think is a good thing for our citizens because they're obviously not inconvenienced to have to go to jury duty solely for personal injury cases. But the truth is that lawyers have to know who their audience is when they go to trial. It's a group of hostages who have been hijacked from their life to come into a courtroom, and they're looking at you like, why are you and your client forcing me here? And you have to kind of expect that and know that, you've got a lot to overcome beyond just your burden of proof, from the legal side. So I think it's important to, for our lawyers who are listening that do not litigate, to have like a pod of 5 to 10 lawyers, that you could easily email a copy of the case to and say, what do you think this case is worth? Those lawyers like me and Nick would probably tell you something for free and not try to be like, hey, bring me in, let me earn a fee, because we want to help and we don't want to take on every case. And so I think that it's important to co-counsel with other attorneys and not get so caught up in your ego.
You brought up 2 immensely important points, and I want to separate them out. So I have a far more bitter approach to pre-litigation. And you talked about how you had a $10,000 offer and you gave them everything and you felt like you justified it, and they said, eh. And that's why I'm far more bitter when it comes to speaking to pre-litigation adjusters. I've given you everything, and they don't have to do anything at that point. There's no anvil above their head, right, is what I say. And so it's not until a lawsuit is filed where deadlines are met, where answers have to be given. And I think it's very interesting how different your approach is in that. Do you ever get frustrated with that? I call it adjuster speak.
I get frustrated at that because I know that I have failed in some way to help that adjuster properly set the reserve. So I now have a task. Right. I take it as my responsibility because what happens in claims is adjusters get assigned to a claim because they think it's going to be in this value, right? And that adjuster cannot go higher. They have a limited amount of authority. And once I did not figure this out. People taught me this. And so really it was Aaron DeShaw and Charlotte Sinclair that taught me this over the years. But it's so important when adjusters reach out and they want injury and treatment status that you don't just scan that letter and put it in the file and don't actually do it. You then assign a task to a paralegal that just says, hey, give this adjuster an update on where we are. Because what will happen is if you update them and they find out your client's received an epidural injection or has a surgical recommendation, they're now shifting it up to a higher level, higher rank adjuster. So before I even send out an offer to settle, on most of my cases, because it's not perfect, but on 75 to 80% of my cases, the adjusters know before they ever receive an offer where the case is. We try to give them an update within the first 30 to 45 days of us signing the case, because they're going to reach out. We don't just like volunteer it. If they ask, we tell. And we just give them some basic information, things that are simple, easy for our paralegals or me to provide them. And that usually leads to them properly setting their reserves so that when they receive that demand for $1 million, they're not just like, well, darn, I'm only at 10. Well, 10, that's it. You know, and so I find that interesting, but is it always true? No. Sometimes you have claims offices like at State Farm and in the past, Allstate, that they're just under a company-wide, like, let's lowball, let's lowball. And you can't help that. But I think for the majority of the time, if the attorney and their staff actually respond to the letters asking for updates on injury and treatment, that you'll notice adjusters change after you give them that update, and that usually signals that the adjuster has more money.
I love your positive view.
It's hard. I mean, I get
I'm
frustrated.
the complete opposite. I'm just like, they're going to delay as long as they can, and this is well documented.
Yeah.
That insurance companies' job is to delay, to break your client down, to keep that money in the bank, to get interest as long as possible.
To make more money on the premium.
Yeah, but you take a very positive view. Like, you got to help them more. You got to snuggle more.
I have to.
Because one of my attorneys whose mother worked for State Farm for decades, that's how he views it. It's, you got to help them, man. They're just regular people. They just want to help you, but I just don't feel that way.
Adjusters are uneducated, generally speaking, on the extent of injuries. They think that someone sustains a hand injury when a cabinet falls on their hand, that if they get diagnosed with carpal tunnel, that must completely be unrelated and pre-existing. Well, sorry, that's not how it works. I'm not saying that from the lawyer side. I'm talking about what an orthopedic hand surgeon would say. You know, actually deposed that orthopedic hand surgeon on Friday, or not Friday, sometime last week. But because I was off Friday. That's the important too of taking time off to be with your family. My daughter's birthday was Friday, my oldest daughter, and so I took off the whole day, and it was hard to let go, you know. But I kept saying to myself, "Wow, the phone's not ringing. People aren't going crazy. I can actually do this. I can actually take more time off."
That's my goal right now in my firm, is to be non-essential. I want to be very important. I want to be very helpful. I want to add value. But if I step away, the place shouldn't burn.
Yeah, and I know like you and I have totally different models, but for me, it's like I'm the asset. I'm the person as to why they come there. But I also, in turn, I have to like read a bunch of medical stuff. I have to read a bunch of boring stuff about how insurance companies value claims. I have to get all this knowledge and do all these things and work some cases, and I don't make money. In some cases, I make a lot of money. Some cases, I lose money. But I've found that if I get all my ducks in a row and I set the table, all right, or I present my case from the best, I put my best foot forward first, then I'm likely going to get the outcome the client wants in litigation majority of the time, it seems, because you have to deal sometimes with bigger policies and just whatever. But for your average car wreck case where the policy limits are less than $100,000, you can actually get that if you speak the language of the insurance company and understand how they value claims, how they set reserves, all that stuff. And it seems like a lot of work, but it's really not. It's just a matter of reframing, your messaging and how you operate. And it's been surprising, because I thought all that was honestly bullcrap. I was like, I don't think they're going to care. Right. But I've noticed differences.
It's very impressive, especially with the size of your team. I'm blown away by that. And that's why I enjoyed this so much, hearing other people's stories. And hopefully you all do as well. How you can get to a level of success without doing it the exact same way.
Yeah, that's true.
And anyone who tells you a single path, a single way, watch this course, read this book, that's the only way to be successful, is false. Right. So you're a testament to that. So without going into specific detail, what do you think you failed to tell this adjuster in the pre-litigation phase, where they only offered you $10,000 and then you got $1 million? Because I view it as they were just delaying and making excuses.
Sure. I think what I come to realize is that I have a responsibility to prove the case, and proving the case also means informing the other side of what's coming. And I can't say that I automatically feel like a failure and I'm like, droopy. It's more like, I can see where I could improve and hopefully prevent this same scenario from happening again. So if I've done my part, and it's just a small little part at the beginning of the case when we sign it up, and maybe when we shift them to what we call the demand prep phase, they've been released from care, we try to give them an update of what's coming. And I think it's led to better outcomes without, the problem with litigation is, sure, the positive is we file it, we get a better offer. But then there's also things like State Farm's playbook is they're not going to actually pay what we want until they take our client's deposition, which is going to be 6 months or so after we file the lawsuit, assuming it's a very basic case with hospital, chiro, maybe MRI and pain management. But I'm just saying all that because a lot of times these insurance companies like State Farm will not actually pay you what you want until you get a pretrial order file, which means you've gone through this whole litigation gambit for several months. And once you file the pretrial order, they're now like, oh, they're going to trial. We better pay them. It's just so funny. But then, yeah, you do get those cases where you file the lawsuit, they take your client depo, they pay you, or you get cases where you file it and they pay you before even inconveniencing your client for their testimony. So, all in all, I mean, I just feel like it's a matter of the practice of law. That's why they call it. And it's like learning from other people and not letting your ego get in the way and just trying to improve and realize the case isn't about you, it's about the client. And so what's really the best interest of the client? Is it you getting all these accolades because you've litigated the case and it's getting what the client wants, right? And so I try to focus more on that.
That's hard for me as a trial attorney. I resolved a big case last year, and we were literally 5 days from trial, and the number went up a lot. And it was, I had several co-counsel in the case because you have to do that when you're going against specialization. And I just wanted blood, man. These people ruined my client's life.
Yeah.
I mean, her life was ruined. And, we had to sit down and be like, Nick, this is about the client. This is a risk you can't take. And it was a scary moment for me.
Yeah.
Because you just get so lost in that client's life. And I know I did.
Yeah, I remember talking to you about that case throughout several months, over a year it seemed. And I just think okay, where's my duty lies with the client. And so is my duty to the client to say, we can get you $50,000 more if we go to trial versus you take the offer now. You don't have to go through that experience. You don't have to talk about, how you urinate on yourself in public. And I'm sorry that's kind of graphic, but that's the truth. People get a disc injury to their back. They have trouble controlling their bowels. They have, bowel incontinence is something that's real. And so I just think, majority of my clients do not want to go try the case unless they're forced to, right? I have some clients that are outliers that think that the justice system is always going to be on their side and that there's never going to be that juror that's going to
Wait, I thought all injured people just want to rush to trial and try to win the lottery.
Right, right. And so I say all that because I think that so much of what we do is this zealous advocacy for our clients, and sometimes that gets in the way of making the deal. And for example, a defense attorney last week wanted me to witness and approve a settlement release. And it was in the state of Alabama. Well, in Georgia and Florida, we do not sign releases. But in Alabama, it's common practice that the attorney will sign just saying they witnessed and approved it. Well, I told the defense lawyer, we don't have a deal because I'm not signing this. And then I reached out to another colleague in Alabama, and they're like, yeah, we actually sign those all the time, and it's common practice. And the judge, because this is a child, we're child settlement, the judge is not going to have a problem with you signing this. I'm like, oh. So I emailed the defense lawyer back. I'm like, hey, sorry, I was getting in the way. I will sign that, okay? And we have a deal, right? So that's the idea of a short and sweet of a lawyer getting in the way of the deal going, right? Well, obviously the deal's going through. But I just say all that because I think sometimes our egos kind of get in the way, our own personal goals sometimes get in the way of what's really best for the client. And knowing that no matter how good we are at portraying the truth and sharing the truth, that sometimes people buy into the lie that the defense will perpetrate throughout the case. And that's something we always have to be on guard for and realize that no matter how much we like ourselves, that jurors, they meet us and they have to decide. And sometimes their decisions are based on truth and sometimes it's based on false information. So best thing to do is focus on, evaluating the risk management with the client and helping reach the client's goal.
And the other point that you discussed previously, and I think really said a lot, at least in my starting a law firm and business journey, a lot of people that worked in defense talk about how combative it is. You know, they don't really talk to each other. They're always constantly competing over clients and contracts and things like that. Whereas in the plaintiff's bar representing injured people, it's been more collaborative.
Yes.
So when I worked for someone else, I rarely spoke to any other lawyers. I just sat in my office and I worked. But once I started my own firm, the people I looked up to who were running their own firms were incredibly collaborative. They said, whatever you need, I'll send you forms. I'll tell you how to do this. I'll answer any questions. I wanted to kind of walk through your experience when it comes to working with other lawyers. Yeah. Have you seen a difference when it comes to
100%. So I touched on this briefly. Like I'm submitting my application to be board certified in truck accident law, and there's less than 100 attorneys that are board certified in the whole country. So this is a big deal. And my mentor has been Brian Mose over at Freed Goldberg. They do nothing but like truck accident cases. I mean, that's the majority of what they do. And so I wanted to kind of help make a difference. And so long story short, I will share as much information as I can with a complete stranger because I like to help. And I think that's for the 99% of the plaintiff's bar, that's the same.
But aren't you worried they're going to take your clients and steal the way you do things?
I'm not, because we're all truth seekers, right? And so I have encountered lawyers that just left the defense and they started their firm. And I got really mad at this one lawyer because she, and I apologize to her for this, but she did not want to tell me where she gets her medical records summarized for a good price because she promised the lawyer that shared this with her that she wouldn't tell anybody. And I'm like, what? Must be a defense attorney, you know?
Yep.
Yeah, because I'm like, I'm not used to that on the plaintiff side. We share, we help, you know, a rising tide floats all ships. And so I had a hard time understanding that because I've never worked on the defense side. And so now I understood, you know, I understood why there was this, like, I can't tell because I made a promise. Well, I respect that. But I understand why people aren't sharing because they're defense attorneys, right? And they're constantly worried that their clients are going to leave. Whereas for me, like, I'm not worried about that. Like, as long as my skill set continues to improve and my integrity and honesty prevails throughout the representation, then I'm going to continue to get more business. And, yeah, I mean, it doesn't bother me. I mean, I'll reach out to you for advice on things. You do the same thing for me. And it's interesting how much we collaborate and never say, hey, Nick, you want to take me to dinner since I helped you?
Yeah, you owe me.
Yeah, you owe me.
You're the only reason you're successful is because, I mean, I love that about representing plaintiffs. It's wonderful, and it's an honor to work with our compatriots. So I want to touch on quickly, you talk a lot about traumatic brain injury. You seem to have a huge focus on that. Explain to the audience, why is that so important to you?
I think it's so important because it is an invisible injury that leads to a lifetime problem. And we all can Google, if you're not familiar with, or TikTok, whatever, you know, the NFL concussion cases. And there will be enough literature out there, or really enough like reels on social media that can tell you all that you want to know about, you know, those cases and concussions. But the reality is that you get a concussion and it is a start to either you make a full recovery, because most concussions do resolve after 6 months to a year, or that a year or so later that concussion's not going away, and so now you have something that leads to cognitive decline as you age, right? And so that's a big element. You can't live without a brain, right? Just like you can't live without a heart.
Brains.
So
we are brains.
We have to have our brain and in order to function and do certain things. And so I just felt like so many cases and so many attorneys who do what we do, we're focusing more on like orthopedic stuff, pain management stuff, and yes, that is important. But we can't forget about the brain, and it's so often missed. It's so often misunderstood and not diagnosed by most emergency rooms, because most patients come in and they give a history and they don't realize they even have the concussion, or they don't know that they lost consciousness, because the brain injuries that we're really talking about, the average brain injury, which is a mild traumatic brain injury, isn't going to be a blow to the head or a gash or a big obvious thing. I mean, you can get a concussion. You can have a permanent life-altering brain injury without striking your head. Just the whiplash effect of getting rear-ended, right? So whiplash is a closed head injury. And so that doesn't mean that, oh my gosh, you need millions of dollars for your concussion. No, but it means that you need to get it diagnosed early in case it turns into a bigger problem and you have a permanent, cognitive impairment that we need to obviously recover money for. And there's no imaging that's going to test and really positively say you have a brain injury. It's almost like a symphony. You've got to have the violin, the cello, the piano, the cymbals. You got to have all these different parts, and every case is going to be different. So I think traumatic brain injury cases are very unique because every person's reaction to it is different. Every case is unique, and I hope all my clients, make that recovery when they don't have residual symptoms and cognitive impairments for the rest of their life. But the next question is like, how do we prove that? And I think so many attorneys that I've listened to have focused not so much on the science or the imaging, the diagnostic imaging, or even the medicine side. They're focusing more on like, let's call their friends, family, and some random strangers in the community that see them and could say, Sandy doesn't recognize me in the grocery store anymore. Wow. She and I used to have conversations. She'd know my name. We'd talk about our families. But I noticed sometime shortly after the pandemic, she didn't recognize me. And at first I thought she was being rude. But then, okay, like how powerful is that? Now the jury's like, wait, this is common sense stuff, as opposed to something up here talking about medicine and diagnostic imaging.
Their eyes roll back.
Right, your eyes roll back and you're bored. So, I mean, again, like, it's a matter of like getting folks together that can really say this person is not the same. Yeah. And then letting the jury decide, or hopefully without a trial, you're able to get the other side to accept that this is a legitimate case with legitimate injury that y'all need to pay to minimize the risk of an excess verdict. So brain injury cases for me have been daunting because I think we all try to control things to a certain extent, right? And I think learning to breathe and expect the unexpected and say the serenity prayer and just know like none of this is in your control. All you can do is direct the client, lead the horse to water kind of thing, and hope that they provide you with what you need. Hopefully they provide you with the names and contact information of members of their community, or they, whatever. So it's really interesting. But because I use the Case Status app, which is a texting app, I have found it so much easier with clients that have short-term memory loss or other cognitive impairments, because they now can just scroll through and read. So helps them stay organized.
I love that. I've said it multiple times. I feel like we're brains in meat suits. You lose your arm, you're still you.
Yep.
You get a heart transplant, you're still you. But if you lose your brain, what else are you? So I want to expand it a little bit more before we close today. Kind of talk a little more personally.
Okay.
If there's one thing you could change about the PI industry, what would it be? What drives you crazy?
I think generally speaking in our country, for us to be, we like to taunt we're the number one country in the world, but we have a broken healthcare system. We have people that have no health insurance, and yet we have this wonderful thing called the Affordable Care Act, which I try to get clients at least to get a health plan, right? It's still a broken system. Even though it's not perfect, it's there. I think just helping people get health insurance, because I know there are cases that we need medical funding, we need ways to help fund treatment because maybe the technology is new and health plans don't cover new technology. They don't. But that technology is researched and tested to resolve this. So if my client can go get an Intracept procedure on their back as opposed to getting a more invasive procedure like a lumbar fusion, which you never want to get, and I could have a medical funding company cover the Intracept procedure, but I could have health insurance cover the office visits, the physical therapy, the diagnostic imaging, everything else but the procedure, because again, health insurance may not cover it. Now nowadays Medicare and other health plans do cover Intracept, but a couple of years ago it didn't. So I say all that because I think it's just making it better for people to get health insurance so that they can then, like once their case resolves, they can continue with their health plan to get coverage. So that's one thing I would change. I think the other thing, you didn't ask me this, but I'll say another thing I would change is making it easier in state court to get to a jury trial. Mm-hmm. Not because Nick and I are just like, we got to try every case. We've noticed that it will resolve faster if the cases get to trial faster.
Consequences are coming.
Yeah. Yes. So I think those are the two changes I would make.
I love those, especially the second one.
Yeah.
That drives me crazy. And I was actually terrifying during the pandemic when everything closed. I thought we were going to close down. I mean, like not having an end game, not having a consequence. Luckily, we were fine. But and you discussed on this earlier. You said you'd like to be retired in your 50s or something like that. But to you, and we've talked about entrepreneurship. We've talked about growing something. We've talked about the multiple ways that we can be innovators and litigators. When have you won, in your opinion? Have you thought about that? Like, when have you done it? You did okay.
I think with any case, when I feel like I've won is that when I've gotten to the truth and I've got my client fair compensation, and the icing on the cake is when the clients, volunteer to give me a Google review. That matters to me. Online reputation matters. And so I have over like 218 5-star Google reviews. And
How's the number?
I had a client one time, her boyfriend went on, left me a negative review. And I'm like, who is this person? I don't know.
Drives you crazy.
And I called the client. I'm like, hey, do you know this person? Because they had a unique name. And she's like, yes, that's my boyfriend. And I told her, and she's like, he doesn't even know you, doesn't know anything about the case. I don't know why, but let me talk to him. And then boom, he removed it. And I wasn't upset about it, but I was like, just want to know why, because I really do care and I really do try. So I think what makes me feel like I won is that I've done the best job for my client. And no matter the bumps in the road, I've gotten them a good outcome, the best outcome I could, considering. So,
Love it.